Welcome to the McCarthy Report, the podcast where I, Rich Lowry, discuss with Andy McCarthy the latest legal and national security issues. This week, what else? The latest on the Mar-a-Lago fight. You are, of course, listening to a National Review podcast. For some reason, you're not already following us on a streaming service. You can find us everywhere, from Spotify to iTunes. And please give this podcast and Andy McCarthy the glowing, indeed gushing 5-star reviews they deserve on iTunes. Now, without further ado, I welcome to this very podcast, through the miracle of Zoom, none other than Andy McCarthy.
Hey, Rich, how are you?
Good, Andy. How are you?
I don't know. We got like the agony and the ecstasy here. Congratulations on Judge. That was a great moment. But my team came up as small as it could come up in the biggest games of the season. So they were in, I guess they were in first place from April 12th until October 1st.
Yeah, not anyone's counting, but I saw the ESPN graphic last night. 170 days apparently in first place, and there are only two other teams that have been in first place that long. It's the Rangers, I think, had a run and didn't make it, and then there's someone else I forget.
Yeah,
but I'm sorry. It's just so, this is kind of a different kind of Mets team, different Mets owner, and then they flame out again.
Yeah, well,
the Braves are good. I mean, the Braves just flat out ran them down.
Yeah, but they had to win one game basically, and they couldn't do it. So you have to take your hat off to the Braves. They're a great team, but it's really awful to, like, if somebody asked me at the beginning of the year that they'll win 100 or 101 and get to the postseason, I wouldn't have imagined that we could get to the end and I'd have a bad taste in my mouth.
Yeah,
it's just the way I feel.
You can do it out of the wild card. It's been done many times before. Get two fantastic starters, a closer, and a couple hot hitters, and some luck. So that's still, I say that's more in the cards for you guys probably than for the Yankees, because the starting pitching is rocky and we don't have a closer.
But you have to play one less series. I'd take that. I'd take that. Yeah. And you got that guy with the bat. So
yeah. All right. So Mar-a-Lago, for a lot of us, this has just been rumbling on. And as of maybe a couple of weeks ago, just got so convoluted, it's really hard to know what's happening with it anymore.
It's part of the strategy, though, don't you think? I mean, look, Trump, if anything, I think that is most accurate has ever been said about him is he's an agent of chaos. It's part of his shtick. And there's good aspects of it in the right circumstances. But for the most part, he's an agent of chaos. And what he has managed to do in this scenario, I've told people over the years, and it's hard to make this clear to people, Rich, without a concrete example, but just talking about it in the abstract. When you're in litigation, you only want one court dealing with a matter at a time, because if you get multiple courts starting to issue contradictory rulings, it's complete chaos. Mm-hmm. The usual rule in the road is when one court is acting on something, no other court will touch it. And Trump has somehow managed now to get 3 courts into this thing at the same time, which is why everybody's head is spinning.
So the court that is acting in contradiction of its prior rulings here, or at least intention, is Judge Eileen Cannon, because she says you need a special master, and now she's pushing back against a special master.
Yeah, well, it's convoluted, as you say, but just to recap for people, I try to lay this out in a linear way so people can understand that there is a sort of a straight line here, and you can figure out what's happening, but there's procedural ins and outs. Basically, Judge Cannon, remember back when the Mar-a-Lago search happened on August 8th. And as we discussed it at the time, she dawdled for about 4 weeks. Trump delayed 4 weeks asking for a special master. And then she delayed another 2 weeks. I'm sorry, Trump waited 2 weeks to ask for one. And just so people remember again, I know we've been through this before, but a special master would be someone who goes through seized materials to see if there's privileged information that the government prosecutors shouldn't be able to see. That's basically the role. The Justice Department has an internal process that they would like to use for that. But if you're a defendant, you don't want the Justice Department deciding what the Justice Department gets to see. You'd rather have an independent person do it. So that's what a special master is. They're only supposed to be appointed in emergency situations. So simply by waiting 2 weeks to do it, Trump should have basically been out of the box. And after he waited 2 weeks, then Cannon waited 2 weeks to rule, and then surprisingly authorized a special master when it looked like she really doesn't have jurisdiction under the law of the 11th Circuit to order one, but she ordered one anyway. So here's where the first fork in the road comes, Rich. She orders the special master on September 5th. The Justice Department immediately files a notice of appeal to the 11th Circuit. What the notice of appeal does is it gives them 30 days to file their appeal. You have to file a notice first, and that starts that clock ticking. So here's, and I guess I should explain this now because these conflicting motives on the Justice Department explain a lot of what happens as we go forward. The Justice Department is torn because they think that Judge Cannon's ruling is completely wrong, that she has no jurisdiction to order a special master, that she's wrong about 5 different ways having done so. But what they're worried about is if they file a full appeal, a full-blown appeal of this order in the 11th Circuit, they are then beholden to the 11th Circuit's setting a schedule. And what could happen in ordinary appellate litigation is that could be months of delay. And during the pendency of that, one of the things, the important thing, the really important thing that Cannon did in her original order on September 5th was she issued an injunction against the Justice Department using the classified documents in the criminal investigation, which in essence meant the 100 classified documents that were seized could not be used by investigators in an investigation of mishandling classified information under circumstances where there were fears that not only had this information fallen into the wrong hands, that is, it's been seen by people who shouldn't have seen it, and they need to find out who, but also some of it's missing. They have reason to think there are still missing documents, right? So that narrow aspect of it was the intolerable part for the Justice Department. So I think they prudently realized that to get the 11th Circuit's attention so that they would rule on this quickly, they couldn't throw the whole thing that Cannon did in the circuit's lap. So to underscore that they were trying to be cooperative, but at the same time, this was what was really important, they filed a limited appeal, ultimately, where they said, look, we disagree with all of this. We think she's totally wrong. But what we're appealing is she shouldn't have given the classified documents to the special master review process. And she absolutely shouldn't have told us that we can't use the classified documents in our investigation. And they figured that would really narrow it in a way that seemed reasonable because there's only 100 classified documents and there's 11,000 other documents. So I think what the Justice Department was trying to do is say to the 11th Circuit, hey, Court of Appeals, here's a nice finite thing where you can see that she's like wrong 8 ways to Sunday and give us a quick ruling. So that's what they were thinking. But the upshot of what they did was it meant that they would be in 2 different courts at the same time. Because since they weren't appealing the part of the ruling that affected most of the 11,000 documents, that meant the special master process was going to get going in the lower court. So you're on 2 tracks. The 100 documents are in front of the 11th Circuit, and the other 11,000 documents are still in the district court. And in connection with the district court, at Trump's request, Judge Cannon, who, let's remind everyone, was appointed to the bench by President Trump in 2020, Judge Cannon I'm sorry, former President Trump suggests the senior judge in Brooklyn, Ray Deary, as the special master. And the Justice Department agrees to that. Now, here we get into another bit of, I think, confused thinking and miscalculation. Judge Deary, Trump believed, would be sympathetic to Trump, or at least Trump's lawyers thought that, which is why they recommended him. Here was their reasoning, Rich. Deary signed one of the Carter Page surveillance warrants in the Russiagate stuff. And because Trump figures he's completely outraged at the FBI, he figures that Judge Deary would be completely outraged at the FBI too. And I think this was a bad calculation because I'm sure Judge Deary is not happy that he signed one of those warrants. But at the same time, Deary's career is as a pro-Justice Department law and order guy. He was the U.S. attorney in the Eastern District of New York before President Reagan put him on the bench. And the whole reason that Chief Justice Roberts put him on the FISA court is because he's deemed to be a serious national security law and order guy. And the other thing I would have been thinking if I were representing Trump is that when Deary was on the FISA court, he had to live within all of these restraints on classified information that Trump flouted down in Mar-a-Lago. So it seems to me he would be the last person to be sympathetic to Trump, but they thought he would be sympathetic to Trump. And what happened when Cannon gave the special master assignment to Deary is, contrary to Trump's prediction, Deary was anything but favorable to Trump's position. And that's where, so Trump is getting a bad time in the 11th Circuit. He ultimately gets a bad time in the 11th Circuit. He gets a bad time in front of Judge Deary. And now, you know, I will get more into the details of it, but now he's trying to go to the Supreme Court because he's not happy with the service he's getting anywhere else.
So you had Cannon last Thursday intervening without actually being asked.
Yeah, she's been Trump's savior through this whole thing. She should not have ordered the special master in the first place. And the interesting thing last week, Rich, was she rode into Trump's rescue when Deary was basically pummeling Trump's team. And she did it only a few days after the 11th Circuit issued its opinion, which basically walloped her and said that she didn't have jurisdiction to do any of this. So the first time we heard again from Judge Cannon after the 11th Circuit rebuked her was to intervene without being asked to do so to help Trump with his Deary problem. And just so people can understand what the Deary problem was, Deary, I probably didn't like reading Maggie Haberman say in the New York Times that when she used to cover the Brooklyn courthouse beat, his reputation was he was the slowest guy of all the judges in the place. So he basically started out by saying, we're going to move this thing. I'm going to get through this. Here's what we're going to do. There's 11,000 documents. It's about 200,000 pages. We're going to get an outfit to, at Trump's expense, to digitize it. And that's going to take a while because of how many pages it is. But here's what we're going to do to move it along. As the company finishes digitizing segments of it, they're going to be turned over to Trump every couple of days. And when Trump gets a batch, he's supposed to assert as to which documents he wants to say he has some kind of privilege. So rather than what Trump wants here is delay, delay, delay. And what Deary says is we're not going to have delay. When you get like 100 pages or 300 pages, you go through it and you tell me what you think is privileged. And then we get the next batch. He didn't want to do that. He wants to wait till the end, right? And then take his time going through all 200,000 pages. In the meantime, Deary also says, you know, all this stuff he's been saying about declassifying all these documents, What's the backup for that? What evidence is there that he declassified the documents? And Trump's lawyers go, humma, 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 because they don't want to say he did it, but they don't want to say he didn't do it either under the circumstances. So Deary makes it clear that he's going to expect Trump's lawyers to provide the evidence that he declassified documents. Now, they probably get off the hook with that because the 11th Circuit so slammed Judge Cannon that the upshot of that ruling was that the classified documents were no longer going to be part of the special master review. So they probably had a good argument that because that point was moot, they shouldn't have needed to provide that evidence anymore. But the other thing that had Deary agitated was Trump's also running around saying that the FBI planted evidence. So what Deary says is, I want to see your evidence that the FBI planted evidence. So the vehicle for doing this is the Justice Department had to give Trump an updated listing of everything that was seized from Mar-a-Lago, which we call the search inventory. And what Deary said is, you need to go through the inventory, Trump lawyers, and tell me, is there anything that's not in there that should be in there? And more importantly, is there anything that's in there that wasn't actually at Mar-a-Lago? In other words, that you're saying somebody must have planted or added after the fact. So Trump's lawyers are like, whoa, we don't want to do that. And then the other thing is Deary says now, and also about this whole executive privilege thing where you are, as the former president, think you can assert executive privilege against the wishes of the current president and against the executive branch. I want an explanation of your theory on that. And with respect to every place that you assert executive privilege, I want an explanation of, are you saying I'm asserting executive privilege against all other entities like Congress and courts, et cetera, outside the executive branch? Or are you saying that you can actually assert executive privilege against the executive branch, even though the privilege belongs to the executive branch? So Trump is like, I don't want to do that. And that's where it lay, according to the directive that Deary gave them, the schedule that they were going to go by. And that was how things were going to go until last Thursday, when out of nowhere, Judge Cannon intervenes and says, this whole business about, Trump having to represent what his evidence was of declassification and what his evidence was of planting evidence. I didn't say he had to do that at this point. The only thing I said was the government had to provide the documents. And to make a long story short, Cannon is treating Trump. I mean, people will say, and there's force to this argument, that Trump put her on the court and she's leaning in Trump's direction. Another way of looking at it is she is treating Trump as if he were a criminal defendant, because she thinks eventually he's going to get charged, and she doesn't think it's fair that he's in a position where he has to give information when, in fact, the Justice Department is investigating him and may ultimately charge him, and giving information now will redound to his detriment later. Now, most of us would say the answer to that quandary is, hey, Trump, don't file a lawsuit, because if you file a lawsuit, you take on an obligation to provide information. But I think that the conservative, non-sinister way of looking at this is that she thinks it's unfair and that he should be regarded more as a criminal defendant than a civil plaintiff, even though he's technically a civil plaintiff. So anyway, she writes in and says he doesn't have to provide information. All he has to do is say he's asserting executive privilege. He doesn't have to explain the assertion. And it's this business about this rolling thing. I'm not doing that. So I think what should happen here, she says, is Trump should get all of the documents first, and then he can take about 3 weeks and decide what he wants to assert privilege on. And the effect of this is to push Deary's schedule, which, by the way, Deary set his schedule according to what Cannon told him in the first place. She says, I think this needs to be pushed back. They said they had some trouble getting a vendor who would digitize these 200,000 pages of documents. And the word that came out originally was, Trump wanted Uncle Sam to have to put up half to pay for all this. And the Justice Department said, no. This is your baby. We don't want to be here. We don't think you should be able to do this. If you want it, you got to pay for it. And Cannon did go along with the Justice Department on that. So what they then said was they had 5 vendors, but the story was that they didn't trust that Trump would pay them in the end. I don't know if they were putting that out because it was derogatory of Trump or if it was real. But in any event, it took a little longer than they wanted to line up a vendor. I don't really believe the story because if the government's involved, the vendor knows it's going to get paid one way or the other. And these guys want to make money, right? So, but anyway, they did line up a vendor. So that part of it is resolved. But what Cannon did effectively, Rich, was push this into mid-December. And that's only Deary's part of it. We have to remember that Deary, even though he's a judge, in this instance, he's not functioning as a judge. He's a special master who's assisting the real judge in the case, who was Judge Cannon down in Florida. So under Cannon's schedule, Deary wouldn't finish his work until mid to late December. And at that point, he makes recommendations to her, and she doesn't put any timetable on herself in terms of when she would decide it. So this would push everything off into 2023. And I think
so in response to this, the DOJ basically says, to heck with it. We're not doing our clever limited appeal. We're appealing the whole thing and just saying you don't have jurisdiction and there's no executive privilege here.
Well, they'd like to do that. And I think they're trying to get that done through the back door. The problem is, technically, they can't unring that bell, right? The what they had in front of the 11th Circuit already was a motion to lift the injunction pending consideration of the appeal. But they told the 11th Circuit, the representation they made to the 11th Circuit to get in the door is that the appeal is only about the classified documents. So the confusion here, and I completely understand why it's confusing for people, is that the main argument they have here is that Cannon didn't have jurisdiction to do any of this. But to get in the door quickly at the 11th Circuit, they said, even though we don't think she had jurisdiction to do any of this, we're only concentrating on the 100 classified documents. But the upshot of that, of course, is if they convince the 11th Circuit that she didn't have jurisdiction, then she didn't have jurisdiction to do any of this. So the thing that I think they want to accomplish is get the 11th Circuit to rule conclusively with respect to the 100 documents, which are the only things in front of the 11th Circuit, that she didn't have jurisdiction. And then what they would do is go back to Cannon and say, nah, see, the 11th Circuit says you don't have jurisdiction. Now cut the cord, abort the special master process. So I think that's what their plan is. They can't really ask the 11th Circuit to cancel out the whole special counsel or special master process because they promised, or they vowed when they filed the appeal that they were only dealing with the classified documents. So that's the box they put themselves in because they felt like they had to do that. And I think they were actually surprised by how conclusive the 11th Circuit's rejection of what Cannon did was. I think if they had known they were going to get that kind of a response, they probably would have taken a chance and gone after the whole thing. So, from Trump's standpoint, it looks like he's going to lose in the 11th Circuit.
So now he's going to Clarence Thomas?
Right. So Trump sees that things aren't going well in front of Judge Deary. Things aren't probably going to go well in the 11th Circuit. So what do you do? So he goes to Justice Thomas yesterday with an emergency application saying, and this is a classic audacious Trump here, right? The 11th Circuit doesn't have jurisdiction to consider any of this. And to me, it's hilarious because the whole thing is caused by the fact that Cannon didn't have jurisdiction in the first place to do any of this. Trump wants to leave what Cannon did in place and say it's the 11th Circuit that didn't have jurisdiction to touch what Cannon did. So just so let's dispel the derogatory stuff that is coming from the media. Trump did not go to Justice Thomas because he figures he's got an in with Justice Thomas, right? Which is what, that's a dark theme that's coming out of the January 6th committee and a lot of the coverage that we're seeing since January 6th. Trump had to go to Justice Thomas if he wanted to try this, because Justice Thomas is the 11th Circuit justice. Every justice on the Supreme Court has certain circuits that are assigned to that justice in case there's an emergency application that has to be made based on cases in that circuit. So, like, for example, Sonia Sotomayor is the Second Circuit justice. If Second Circuit's in New York, if there's any emergency application that comes out of New York, you would immediately make an application to Justice Sotomayor. And the way the law works, under some circumstances, the circuit justice, if it's clear enough, the circuit justice can just rule on it. But what they customarily do is they refer the matter to the entirety of the court. If they think it's anything that, either has some substance to it, or for whatever reason, the justice doesn't want to be in a position of deciding it on his or her own, what they will do is they will refer the matter to the entire court. We saw that a lot, Rich, with the COVID litigation. A couple of times, I think things got, like, for example, the New York litigation challenging what Governor Cuomo had done. That went initially to Justice Sotomayor, and then she referred it to the whole court. So that's what they typically do. So I think under the circumstances, this is so clearly wrong, and we can get into why. I think ordinarily what Justice Thomas would do is just deny it, would dismiss it. But he'll probably refer it to the whole court, because I think he'd rather the whole court spoke with one voice on this than that he did it himself.
And then, Andy, I have to say what I think will happen is the 11th Circuit will rule that Cannon didn't have jurisdiction, but won't get into the executive privilege issue. That's my prediction, Andy.
That's your prediction, is it, Rich?
I'm just cribbing from your notes, of course.
Well, first of all, I think we can dispense with the Supreme Court. That's the big story today. I mean, I've already heard about it, 15 different places, because Trump went to the Supreme Court. I think the Supreme Court's going to look at this and say, we don't want any part of this. And we certainly don't want part of it when we have a ready-made excuse to stay out of it. Mm-hmm. And the ready-made excuse is, this is all in front of the 11th Circuit now. Mm-hmm. And the Justice Department is already asking the 11th Circuit for an expedited appeal. I think what either Justice Thomas or the entirety of the Supreme Court will say is, we're dismissing this for now. All the arguments you want to make to us, you can go make them to the 11th Circuit. And then when the 11th Circuit rules, you can come back and try to appeal to us, and we'll look at it then. But at least then we'll have, ordinary process, and we'll have a decision from the 11th Circuit, and then we can decide what to do. So my prediction on that actually is that even then the Supreme Court is going to say they don't want any part of this, because by that point, there'll still be a pending criminal investigation, and probably Trump will not have been charged at that point. So why do they want to get involved in this if they don't have to? And especially if the whole mess here is because Judge Cannon, under the law of the 11th Circuit, didn't have jurisdiction to do this in the first place, then an 11th Circuit ruling that she didn't have jurisdiction should be conclusive. There should be no reason for the Supreme Court to butt in there, because there's no point in it. So I think this is a very unattractive litigation to get into in the first place. And I'm very confident that they won't want to. They don't have to do it, and they won't want to do it. So I think they won't do it. And then I think your prediction is dead on accurate, Rich. I think precisely it's not. Look, I think the reason I think that they'll reject the idea that Cannon had no jurisdiction to do this is that they've essentially already said that in the preliminary ruling that they gave. So it would be extraordinary for them, having said that, to bite back on it, especially when there's number one, there's no reason for them to contradict what they already said. And number two, I think they're going to be pretty angry that the first thing that Judge Cannon did after they ruled in a way that, said that you shouldn't have done this in the first place, the first thing she did was, unbidden, she jumped in and basically countermanded the special master that she appointed at Trump's recommendation, who she shouldn't have appointed in the first place. So I think they're going to find that aggravating. I know I would. But I do think on the other thing the Justice Department is trying to accomplish here is they would like to get a ruling from the 11th Circuit that Trump doesn't have executive privilege. And I think even though the 11th Circuit may agree with that, I certainly agree with that. I think what the court is going to say is, look, we're saying she doesn't have jurisdiction. So if she doesn't have jurisdiction, then there's no reason for us to get into, the intricacies of the litigation, including the privilege question. And any court, even if it feels strongly, and I feel pretty strongly about this, that a former president I don't think a former president should have executive privilege at all. But if you assume, for argument's sake, that a former president has some vestige of executive privilege, you can't assert it against the executive branch. The privilege belongs to the executive branch, not to Trump. So I think the 11th Circuit probably agrees with that. But any good court is going to want to say, look, we want to see what document exactly are you asserting executive privilege, and what's your precise argument that you have it. These are the kinds of things that you don't want to rule on this stuff in the abstract, especially if you don't have to. So I don't think they have to make this a matter of grand principle. They can say she doesn't have jurisdiction, and they can tell the Justice Department, look, if disputes come up after we've now ruled, we're saying what we've said. If from here on out issues come up about executive privilege, come back to us then, but come back to us on a concrete record where we can see exactly what documents he's asserting privilege on, and then we can look at it that way. So here's the question, Rich. What happens? Let's assume that this happens on the schedule that the Justice Department asked the 11th Circuit to adopt. What they asked in their papers is basically to brief this on a very tight schedule. Like they get their brief in, I think, in the next few days, and then Trump would have to get his in a week or two. And then the court would basically hear the case in mid-November, which is, by appellate standards, that's pretty fast. So let's say the 11th Circuit does what it did the first time around, which is it decided this rapid, quick, right? So you get to mid-November or late November, Thanksgiving, and the 11th Circuit rules, and they say Cannon didn't have jurisdiction, but we only have the classified documents in front of us. So here's what the Justice Department's quandary will be at that point. They'll have a ruling that says she didn't have jurisdiction, but the 11th Circuit can only affect the 100 documents. As for the other 11,000, the Justice Department will have two choices. It can either go to Judge Cannon at that point and say, look, the logic of the 11th Circuit's decision is that you shouldn't have done this in the first place. We respectfully ask you to abort this whole experiment. Let's just end it. The alternative is, by late November, Judge Dearie will probably be through all of the documents and perhaps be ready to make his rulings or make his recommendations, or be very close to that point. And the Justice Department may figure, number one, the only thing at issue here are the non-classified documents. They're not unimportant, but they're not nearly as important as the classified documents to the investigation. Judge Dearie has already exhibited that he's favorable to them. So they may not want to be seen as asking her in desperation to abort in a situation where he's probably going to make recommendations in their favor. And they may also think that after the 11th Circuit slaps down Cannon again on what she's done here, they may get better behavior out of her. Like she won't do anything wild and crazy. So I think the quandary the Justice Department will have if they get a ruling in, say, late November, early December is, should we go back to Cannon and ask her to abort, or should we just sit tight and see what Judge Dearie does and see where it goes from there? My inclination would be to do the latter, but as we're sitting here for what is this, the third or fourth consecutive week talking about this sordid thing, who knows what friggin' crazy thing will happen between now and then that may change their position. I mean, this thing is such a moving
I think
target.
we did skip 1 week, or only hit it lightly 1 week. So Andy, last thing before we hit a few other things in the time we have left. So how does all this back and forth and machinations and rulings and counter rulings, how does it affect what seems to me the ultimate most important question, which is whether he's going to get indicted over this?
Yeah, this is a great question. I think, Rich, it goes back to something we talked about when this whole Mar-a-Lago thing first erupted, which is, I think there's the political versus the legal, right? I have been convinced from the beginning that the Justice Department really didn't want to prosecute Trump on this stuff. I thought it mainly wanted to get its documents back. I think I've been shown to be at least partially wrong on that, because the Justice Department, there were clearly people who are working this case who want to charge this guy, and they are going at the classified information very seriously. They're going at the obstruction very seriously. What I've always thought, just like politically and I don't want to say legally as much as knowing how the Justice Department works, maybe culturally, I've always thought that even if the Justice Department knew that there's a lot of problems attendant to charging Trump could talk himself into getting charged by continuing to go out and put everybody's honor in question. You know, say the FBI planted evidence on me. Every time he says something crazy like that, he gives a stronger hand to the people inside the Justice Department who are saying, the only way we can correct the public record is to indict this guy and prove in court what he did. Mm-hmm. And that becomes a stronger argument every time he goes out and accuses them of wrongdoing. Mm-hmm. And then there's the other thing, Rich, which you're as or more well qualified to address than I am, which is, I think the Democrats want to run against Trump. Mm-hmm. Yep. And I don't see how they run against him if they indict him. You know, I think indicting him effectively takes him off the field. In fact,
why do you think that?
Because once he's indicted, he loses control over his ability to carry on a campaign like an ordinary candidate. I mean,
so you just couldn't outsource it to the lawyers, and because I imagine the
campaign.
No,
Rich, he could be detained.
Legal offense.
He could be detained.
Maybe
he could be
arrested.
Classified information and obstruction are serious issues. And while I don't think they would detain him prior to trial, they could impose a bail order that didn't let him leave Mar-a-Lago, and he would be doing the Biden campaign. He would be campaigning from his basement, just like Joe. Well, that worked out the last time, right?
Yeah, but the reaction would be so. I mean, I think on the right, it'd make the reaction of Mar-a-Lago look like child's play.
On the Trump right, I think that's true. Mm-hmm. On the other hand, by the way he has behaved, Trump has caused a lot of disclosure to be made about this case that wouldn't otherwise have been made. And I think what people are starting to see is this was pretty serious business. And it looks like a number of people who were well-meaning and in Trump's corner went down to Mar-a-Lago to say to him, hey, boss, this is like serious stuff. They want their stuff back. You know, mm-hmm. The classified information, you can't have that. No good. And he not only ignored them, the reporting the last 2 days is that he explicitly told lawyers of his to make misrepresentations to the National Archives, to the grand jury, and to the Justice Department about how much stuff he still had in Mar-a-Lago, which means with every one of those disclosures, and this is why I think the lawyers are being pressed so hard now, with every one of those disclosures, he's making the obstruction case stronger. And obstruction is something, not only that the Justice Department, but courts treat pretty seriously. When you're talking about like whether somebody gets released on bail pending trial, one of the things courts want to know is how confident that can we be that evidence won't be destroyed and that witnesses won't be intimidated. So, I know it seems inconceivable that you could be in a situation where the question would be, would a court basically detain Trump pending trial if he got charged? I would just say, Rich, that in July, it was inconceivable that a search warrant would be issued for Mar-a-Lago, but that happened. And all the stuff that we've seen in the last 2 months would not have been predictable, but it happened. So we're in like totally uncharted territory. The big question here is what do Merrick Garland and Joe Biden do? And, Joe Biden will say, this is all on Garland. I don't have anything to do with it. That's a bunch of, what I'm not allowed to say on this family podcast. But, I think they want to run against him. So I anticipate that Garland will rely on the idea that it's a bridge too far to indict a former president who might be the Republican nominee in the next election. And that'll be a colorable reason not to do it. But I think the real reason will be this is like the best of all worlds for the Democrats because Trump is very wounded by this. I think it underscores what I've been saying, since January 6th, which is he can't win a national election. He couldn't win a national election before all this happened. This makes it even worse for him. As far as I'm seeing from the polling, he's like the only Republican who loses to Trump, right? To Biden. But he could be nominated. And for all the reasons that you just said, people are going to be on fire over this. They already are. We had one maniac who said that after the search, after it was discovered that he was hoarding classified information down there, you had people say he should be nominated by acclamation because they searched the residence. So what people were worried about is not that he was holding highly classified information down there, but that they had the temerity after a year of trying to get their stuff back to finally take it from him.
Yeah,
so
it just seems that if they indict him, there's the disparity with the treatment of Hillary, which we've talked about, but then also to have any form of detention at a time when, you can mug someone in New York City streets and be out the next day. It'll be thermonuclear. And I understand why you say, oh, this will just be among the Trump right, but the Trump right, it expands and shrinks. And this would be, the Trump right would be taking an enormous market share, which it already has, in reaction to this. So I don't know. I sort of think indicting him means you want to run against him, but
I just don't see how he runs. They want him to win the nomination. He's not going to win the nomination if he gets indicted. I just think that changes I think he may not win the nomination anyway. I think people, I keep hoping people will come to their senses, and whether it's DeSantis or Youngkin or somebody else, they'll figure we can have Trump policies without the baggage of the persona, and this is just too much for
That would be the rational calculation.
Well, this could expedite it.
Yeah.
But look, if either you or I could figure out where this goes from here, then we should end the podcast and go to the track and make some money because
All right, let's try to get to a couple other things. One, Biden's lawless student loan forgiveness. It's been widely acknowledged that this thing would have major difficulties in court, to say the least, if it ever got into court. And now we have 2 attempts to get it into court from a guy who I think has some tax liability that he wouldn't, and from a handful of states. So what's your take on the likelihood of these folks being able to have standing?
Well, I'm happy to say, Rich, because when we were in California a few days ago, I had the unusual situation of being in disagreement with Charlie on the issue we were talking about then, which was the FBI. I'm now go back to my default position of being emphatically with Charlie on this, which I think he's written and spoken on this better than anyone I've seen. And it's a very highly unusual situation in that I think everybody sees what the bottom line is, which is that what Biden did was utterly, completely lawless. And the challenge here is not to persuade on that ultimate issue, because that's clear, but to get into court, to have a sufficient injury that a court will entertain the suit. And, especially by those who are Biden fans, you read some of the stuff that's been written, and you would think that standing was an insuperable restriction on getting into court. It's not. Look, I favor courts being persnickety about standing, because the idea behind that is when you have issues that are of national importance and that ought to be decided in the democratic process, we don't want them decided by the courts. So unless you can show that you're not objecting to bad policy and that you have a unique, concrete, damaging injury that you've suffered that a court can address, then those issues shouldn't be in court. They should be in the body politic. But that doesn't mean that it's that hard to show an injury that a court will find cognizable. And in this instance, there's been two categories of injury where people have asserted standing. The first one was the one that was filed by the Pacific Legal Foundation on behalf of a taxpayer in Indiana. But there's apparently people who fit this same category in about 6 different states. And that is that they already had debt forgiveness under another government program that forgives debt if you go into certain kinds of public service, which of course the government decides what public service is, right? But so the idea is if you go into public service, your debt is forgiven. Those people, because they're in that program, were automatically enrolled in Biden's debt forgiveness. And the problem is, under Biden's debt forgiveness, unlike the government program, in those states, debt forgiveness is a taxable event. So they will sustain a tax penalty under Biden's program that they wouldn't had Biden not done this. So they have an injury that's unique to them. I thought that was a very clever theory. I think it certainly works, but I wouldn't go up in a balloon over it, because I think Biden can tinker with the executive order so that those people aren't automatically enrolled in his debt forgiveness. And if they're not, then the tax penalty won't get triggered and they won't have standing. So I think Biden will be able to get around that by just some clever drafting. On the other hand, there's states now that have filed a suit, and that's the second suit. And unlike the other situation, the state suit is a much more standard or much more routine invocation of standing. The issue with that is the states service the loans, so they're going to sustain some financial loss by virtue of the program. That's a pretty ordinary way of getting standing, and I don't think it's one that Biden can write his way out of. So I think the states will certainly be able to bring their suit, and maybe the taxpayers will too. But I think the states will get into court.
And then finally, we had this really wonderful ruling, a 288-page decision from an Obama-appointed judge on key elements of the Stacey Abrams case against Georgia. She, of course, has argued that the election was stolen from her in 2018 because of voter suppression. There's been all sorts of voter suppression since then. Some of the stuff fell away because Georgia changed its law in 2019 in some respects. But these 3 things remaining were pretty central to her case. And he just totally gave them the back of his hand, saying repeatedly, so where's the voter harm? And saying repeatedly the state had a legitimate interest in trying to protect from duplicate registrations or people who doesn't exist registering, et cetera, et cetera.
Yeah, I think I want to say two things about this, Rich, that aren't so much addressed to the legal niceties, because I think the judge just walloped them um, on that stuff. But there's the one aspect of this that I don't think gets covered enough, particularly in the media, because the media is run by, basically the media is run by progressives who want to be seen as like the saviors of Black people. But in the meantime, the arguments that they make are insulting to Black people. I saw something that was in the coverage around all this stuff, where a reporter, and I admit this was on I think this was on Fox, but it was either on Fox or it was on a right-wing website, but where they went around and they randomly asked Black people, like, do you have any trouble voting? Mm-hmm. Like, do you have any trouble with like a requirement that you have to show identification, or and they were like, you don't think Black people know how to vote? You don't think we get, you don't think we get ID, and it was really, I mean, it's really insulting to them. And I just think that it's a shame that, so many of these institutions and especially, look, I'm going to get to this with respect to Major League Baseball in a second, but like, I mean, all these companies and institutions that have been captured by woke progressivism, they're making arguments that are absolutely insulting to the people who they purport to be championing. And then I guess the second thing I want to say is to bring things around to where we started, notwithstanding our critics out there, let's talk baseball. I mean, they got the All-Star game out of Georgia because this was a racist bit of legislation, and it turned out that, what was it, 700,000 more people voted under the new system than under the old system. I may be lowballing it. This not only didn't prevent people from voting. If you look at the numbers, it facilitated people's ability to vote. Yeah. And yet, they got the All-Star game moved out of Atlanta, which only hurt vendors and other people in Atlanta. It didn't hurt the rest of the country.
Totally based on a narrative.
Yep.
Yeah. So per your point of African-American voters saying, hey, we know how to vote. I was on the Megyn Kelly podcast Monday, and we're talking about these signs that people put up and, where their houses are devastated, and Fort Myers say, if you come take this and I'm going to shoot you, right? Don't you loot, I shoot. And people are portraying this as racist, as though the only people who would ever steal anything are African American. Like they're no white lowlifes in these communities who would come and take stuff and be warned off by the sign. But you're right. There's this like deeply insulting thread through a lot of this.
Yeah, I just think that maybe that's the secret to getting us out of the rut we're in, and maybe it's more gradual. And it'll happen more. Maybe it is happening gradually, and I'm just not as cognizant of it. But I just think that, this woke progressivism is capturing institutions and weakening the middle in America by doing that at the very time that the people that it purports to be championing are starting to fall away from it because they don't buy it.
Right.
And we just have to hope that dynamic picks up speed.
Absolutely. So that's all the time we have. This podcast has been produced by the incomparable Sarah Schutte. Thanks to everyone for listening, and thank you, Andy McCarthy.
Thanks, Rich.